Okay, I'm recording. This is Stephen Kinsella with Kinsella on Liberty, episode blah blah blah. Um, as you can tell, I don't do this that often where I record an episode myself. Usually this is my podcast feed where I just use it to put in interviews I do on other people's shows. On occasion, I talk to someone, and that's what I'm doing today. I've got on the line my old friend and my old boss, Bill Norvell, calling in on the phone because we couldn't get the Zoom thing working from his home in New Braunfels, Texas. Bill, are you there?
I am indeed.
Okay. And just to let everyone know, so you and I haven't talked in, I don't know, 25 years maybe?
We talked a month or so ago for a little bit, but I
Yeah.
haven't had the pleasure of seeing you and chatting with you in quite a while. I must tell those that are listening and watching that I consider you to be one of the finest minds I've ever had the pleasure of being around in my life.
Well, thank you. That's nice. I thought I would just, I have people that are interested in my libertarian theories and my intellectual property stuff. And I thought I would, you said something the other day that made me think, oh, Bill actually thinks a little bit like I do, which is rare for a patent attorney. And because you're my origin story, I thought we would just talk about that. But first, I wanted to catch up with you, see what you're doing. So you were in Houston, but you're now retired to New Braunfels most of the time. Is that right?
That's correct. My wife's family had property on the canal, right on the Canal River in New Braunfels, and it's been in our family for 7 generations. And so, been coming here from when we were dating in 1969, uh, and so it's just been very habit forming. And so I've been a resident here probably for 10 or 11 years and enjoy it very much, although I have a home in Houston that I travel to. I was just there over the weekend from time to time because my daughter and my granddaughters live there, and our home is right next to theirs. So I do a lot of commuting with many miles on my truck.
Have you ever heard the informal legal distinction between domicile and residency?
Yeah, I've heard
Yeah,
it.
home is residency is where the home is, and domicile is where the heart is.
Yeah, I've heard that. It's been a while, but I do recall that. That's
So
absolutely. I would
so
have
which
to
one's
say.
yours? Which one's your residency? Which one's
I
your?
would say both of them are in New Braunfels. I like it. The living is slower here.
Hmm.
It's one of the fastest growing places in the United States. It's halfway between San Antonio, Texas, and Austin, Texas. So if we want a lot of cultural things, we can go to either city, and we do. And it's not that far. It's 167 miles to the west of Houston. So it's located in a very good area of the country.
Hmm.
Because it's growing so much, and because we're so short of rain here this year and last year, the rivers unfortunately are drying up. A lot of tubers come to New Braunfels to tube and drink beer and whatever else
Mm.
they have down the Canal River.
I thought you might mean potatoes.
it so it's really sad
Yeah.
because the river, instead of being it's a spring-fed river. Instead of being pure water in the mornings, that you could just see it's crystal clear. It's
Hmm.
now brown.
Hmm.
The flow is real slow. I haven't been in it in 2 years because I just don't think it's healthy anymore.
Okay. Well, so are you totally retired now, or what's your situation?
I am. I am. I've been asked by my law firm, former law firm, Akerman, to help prepare some expert witnesses in patent law, do some other things, and I've really declined it.
I see.
The main reason is that once you retire, you kind of direct your time and attention to other things, and quite frankly, I've not kept up with the changes in the law in my area of intellectual property in several years. So I don't feel comfortable with it. Don't really need the compensation for it at all, and so I am retired.
Okay. Well, I wanted to just tell people. So how we met. I moved from Louisiana, LSU, and then I went to London for law school, for grad school, but then I took a job with Jackson Walker, your former firm in Houston, doing oil and gas law with my first boss, Lanny Yates. And then when I was there about a year, my wife, Cindy, told me, I don't know if you know this whole story, but Cindy told me she was an engineer at Arco Chemical, and they were headquartered
I
in Newtown.
recall. I
Yeah.
recall that. Yeah.
And so they were headquartered in Newtown Square, Pennsylvania. And she asked me if she said she could move from engineering into the business side in logistics. And she thought that would be good for her career. And she asked me if I could move to Philadelphia. And I said, well, they don't do oil and gas law up there. I said, however, I have an engineering degree, and everyone has always told me I should be a patent lawyer. So maybe I should switch. That's a federal field. And so I asked around at Jackson Walker, and they said, well, we only have one patent lawyer, and that's this eccentric guy named Bill Norvell up on the 43rd floor. I was on the 44th, 42nd, if I recall.
Yeah, that's right.
And I called you on the interoffice phone, and you hung up on me because you didn't have time for a snot-nosed young associate. And
I don't remember that. I can't believe I did that. But
I tried again, and you hung up on me again. So I sent you my resume and a work sample from previous clerkship in the interoffice mail, like I was interviewing for a job. And you said you threw it in the trash, but then later that day you had a trademark appeals brief which had the same issue. So you dug it out of the trash, and you called me up and said, come on up, let's start talking. I think that's what happened, is my memory anyway.
well, it makes for a good story. I don't recall this. I can't believe I'd be that rude.
Well, I think you're busy, but I didn't care. I didn't care. I was, and so then I said, I want to start splitting my time half time in the IP department, and you basically taught me patent law. You got the firm to pay for me to take the patent bar exam at University of Houston, which I was doing the whole time basically so I could move to Philadelphia. But anyway, I enjoyed learning from you. You taught me that technique I used until I retired, which was getting the dictaphone out and recording a discussion with the engineers, and then getting the typing tool to transcribe it later. I didn't know any patent lawyers that did it that way, but I found that to be very useful.
Well, let me tell you why I use that system. I would go through my career. I mean, I did use it for years. I'd just take a tape recorder with me, a small one, and I would go and visit with the engineers or who I refer to as a discloser, not an inventor, because you can't tell who is an inventor till you write the claims in the patent. But I did that so that I could concentrate more on what the discloser was saying to me, and I had it word for word. And so, Stephan, I think you'll agree with this. As patent attorneys, what we really are translators.
Yeah.
We take the word and disclosures of others and kind of mix it with some law. So I had, by doing that, I could use the same words that the disclosures did, and if we had drawings or layouts or sketches or schematics or anything like that, circuitry drawings, I could use the same terms that they would, and I would ask them, okay, what is the problem that you're trying to solve? I'd always start with that, and then I would say, now we're looking at drawing number whatever it is, and tell me what it is, what view it is, and what are the parts, and so forth on it. And so when I'd get back to the office, I'd have my secretary normally transcribe it, and I would take that and work from it to prepare the patent application. The worst thing that could happen to you, I think, in preparing a patent application is coming to the point where you don't know what something is.
Yeah.
Oh, I forgot to ask you, what in the
Right.
hell is this thing over here?
Right.
And then you got to stop and you got to
Yeah.
go ask them and so forth.
Hmm.
So I was very careful so that when I left, I knew as much about what he or she had
Hmm.
really as they did. I just
Hmm.
sponged it out, and it was for me. It was very, very helpful.
Well, it helped me, and I still don't know anyone who does it that way. But I noticed a few times in my career, I would it freed me up to ask what might appear to be dumb questions too, because you're just having a conversation with them, and you're not worried about the details because it's going to be on the recording. But I remember I would talk to these engineers with these really complicated inventions, like electrical or software from Intel, companies like that. And
Right.
and after I was, and they would get frustrated because I would ask dumb questions like, why would you do that? And they would say, well, obviously I would do it for this reason, but it's not obvious to me, right? And then I would write the disclosure and send it to them, and they would say, wow, I thought you were really stupid, but you actually were listening. They
Yeah.
realized,
Yeah.
yeah, they realized there was a method to the madness, right? A reason I was asking these questions. But I love that. And I remember the first, I didn't really know the difference between a patent application or disclosure and the patent that was published later on. So when you taught me how to do it, the first time I wrote my patent application, I showed it for you to review. I did it in the format of a published patent. Like I had the title, I had the abstract, I had the fields, the search fields, and you started laughing. You said, "What are you doing? This is not a patent application. This is a published patent, but you haven't published it yet."
Well, I remember you were very good, and you were a, a very, very quick learner, and
Yeah,
you just leapfrogged so fast. Things that take people months and years to learn, you did it in hours. So it was, and I'm not kidding. I'm not exaggerating. So you had a brilliant mind, and you also had uh, we had many discussions and many margarita drinking contests
it's true.
over politics and so forth. And so I could, I would say that you are the most brilliant mind. Again, I'm repeating myself, that I've ever had the honor
Mm.
of working around. We had a lot of fun, didn't we?
Yeah, we did. It was a lot of fun. We even got in trouble one night at was it Los Alamitos, which is unfortunately closed down.
Yeah,
Yeah.
yeah, yeah.
Um,
We were having a margarita drinking contest,
yeah, I think it
and
was a tequila. I think it was a tequila sipping contest or something, if I
oh
remember.
yeah, yeah. We forgot. We forget the margaritas after a while. We just started drinking it straight, and they were trying to close, and we had been there for hours, hours and hours. And we both left there. Surprisingly, we were talking so much and concentrating with respect to each other. It wasn't light talk; it was very
Yeah.
deep. And if I remember right, we both walked out there sober as a judge.
I think
You
so. It was
drove away.
strange.
I
Yeah.
did.
Yeah. Yeah, it was strange. Your wife was worried, but it was strange.
Yeah,
Um,
yeah.
um, I wanted are you still into opera? I remember you were really into opera and your hi-fi
Yes,
system,
I have.
listening to your music in your listening room at your house. I remember that.
Yeah, yeah. I do indeed. I have loved that genre since I was about 13 or 14 years old, and I have collected CDs and tapes and DVDs of opera performances. I have over 2,000 CDs or DVDs or
Hmm.
tapes or whatever of different operas, 2,000 different operas, many of which I have several recordings of. I have so many of these that I have them in a warehouse here in New Braunfels, and a storage facility in New Braunfels, and so I go there to get what I want for a while, and then listen to it, and then listen to them, and then I come back and get some more.
You would get along with my son. He's a college senior. He's about to graduate. He's a philosophy major, and he's into all kinds of arts. He loves opera. He and his friend flew to San Francisco a couple months ago to see one of the operas of Wagner. It was like a 5 or 6 hour thing, and we were actually in Vienna this summer looking at architecture for one of his studies, and we walked by the opera, and he wanted to go in and just get a ticket, and I said, I can't go in dressed in shorts, number one, and number two, I don't think I can take a 5 hour opera right now.
Well, Wagner was never known for writing short operas. He had a 4-night, one of his most famous operas is or are a series of 4 evening operas. The totality of them is called Der Ring des Nibelungen. And it is a total of about 17 hours. First night is Das Rheingold, the Rheingold, and then Die Walküre, and then Siegfried, and then finally the last night, culmination of the others, Götterdämmerung, the Twilight of the Gods. And all of these, Das Rheingold's about 2 hours and 20 minutes. Valkyrie is 4.5. Siegfried's about the same. And Götterdämmerung is particularly known for its first act, which is 2 hours long. But it goes by very fast if you're an opera lover.
I bet. I don't know if I could handle it. It'd be like Chinese water torture. There is one of my favorite writers is a fantasy writer named Stephen R. Donaldson, and he wrote a science fiction series. It's a 7-part series called the Gap series, and it's loosely based on the ring cycle in the plot. But
yes.
Anyway, I wanted to ask you, so you were you a technical, where did you go to your undergrad? Where was your undergrad degree
Well,
from?
I started, I went to a college that was very close to Houston, 100 miles to the east in Beaumont, Texas. And at the time, it was called Lamar State College of Technology.
Oh, okay.
And it later renamed as it grew and grew to Lamar University. And my minor was in chemistry. My major was in really pre-law.
Okay.
Kind of a combination of government and history.
I was wondering what your So I was wondering because most people, I don't know if they know, but I don't know if it was the thing in your day, but you have to have a technical degree to be a patent attorney. And I forgot what your technical degree was. So it's chemistry.
Well, you had in my days. I don't know whether they do it now or not. I didn't have a degree, but you either had to have a degree or prove to the patent office that you had sufficient technical background. And after law school, I went to University of Texas in Austin. And after that, I went to work immediately for a company called Milchem Incorporated, which was surfactants, dispersants, and so forth for the oil field, for the completion and workover of oil wells and oil well drilling fluids, or mud as they called it.
Yeah.
So I had I spent about 2 years there with working right in the laboratories with the chemists and so forth. And then my mentor was a man named Delmar L. Schroff, who was with Baker and Botts, a big law firm in Houston. And I had sufficient probably more sufficient background to take the bar exam, which I did. And by the way, if I recall, I was either number 2 or number 3 in the nation. Some bozo in New York City and in Queens, I believe, beat me out. But that's the story of how I got into it.
Yeah, but you didn't, if I recall, the ones we worked on together, you weren't specializing only in like chemicals. You did like oil field
Oh
stuff
no!
and mechanical
Oh
and
no!
medical devices and.
Right. I did in my career. The first half of my career was spent really on the application side, and the other half in litigation.
Mm-hmm.
But in my career, I've done chemicals, electrical, mechanical, semiconductors. I've done health things, and
Okay. Yeah.
I've
So
done
you
everything.
yeah.
As I said, we're translators. We
Yes.
don't. I remember one lawsuit I had representing one of the very well known doctors, surgeons in Dallas, and so I had to learn all of the technology with respect to shoulder replacements and knee replacements, and I knew all of that up one side and down another. And within 2 weeks after the litigation was over, which we were very successful in, I couldn't have told you a knee from a finger. Once it was over, it was over.
Right.
And but I knew enough to at least convince people that I knew probably more than what I really did. But that's a function of us that work in the patent
Right.
area, whether it's litigation or whether it's transactional work.
Right. And just for the people listening, so to be a patent prosecutor, we call it, which is someone who prepares patent applications,
Yeah.
which is what I mostly focused on in my career. Well, until I became general counsel and did a lot of things. But sometimes we specialize. I specialized in the later days in lasers and optoelectronics and software.
Yeah.
But you were more of a jack of all trades, and then you did patent litigation. I only did a little bit of that patent litigation support, but so there's patent litigation and patent prosecution, and to be a patent prosecutor, you have to have a technical degree and pass the patent bar. To be a patent litigator, you just have to be a patent an attorney in who can practice in federal courts, basically.
Right. I always considered myself really. I really did phase into the litigation aspect of it. Not that long after I had been specialized in transactional work, but I always like to say that I was a trial lawyer who happened to be a patent attorney.
Right. Yeah, I get that. Now, when you and I were working together and we talked was I was a full-blown libertarian then. Was I hitting you with all my libertarian stuff all the time?
Oh yeah, and I kind of I thought it subconsciously,
Mm-hmm.
but I really bit into it more than I thought, because as the years went by and so forth, I have embraced it a lot more. I consider myself politically a centrist,
Right.
and by that I mean I think I lean towards supporting people and ideas that I think are good for the country at that particular time, and it shifts. However, I have a lot of respect for libertarian views. My wish is that they would be funded a lot better than they are. I don't think they'll ever get to be significant until some big multi-billionaire or trillionaire really puts a lot of money in them. I must it must
I
tell
think
you that I voted Libertarian in the last
I know you
presidential
told
election.
me. I was pleasantly surprised. I think the only hope of what you're talking about is if we have a lot of libertarians and Bitcoin people, and so if Bitcoin ever, hits $10 million a coin, you're going to have a lot of libertarian billionaires out there. So maybe they'll fund libertarian activism. But
That's correct.
so you said you
That's
told me
correct.
you couldn't vote for Trump and you couldn't vote for Harris, obviously. So you actually voted Libertarian this time. What was your reason you couldn't vote for Trump and Harris?
Well, uh, that's pretty easy. Harris was just way too liberal for me, way
Okay.
too liberal, and I didn't think that she was qualified. Um, uh, I, I just I thought she was uh, supported by Biden, really for purposes of getting Biden elected,
Yeah.
and I couldn't, I just couldn't go for Trump, although I am a supporter and was at the time of a lot of his ideas and philosophy.
Mhm.
The personality of the guy just made me
Mhm.
vomit.
Are you glad
Uh,
that he won though? Are you glad that he won?
yeah,
Yeah. Yeah.
absolutely,
Yeah.
no
Interesting.
question about that. And I've
Interesting.
learned, and I think the country and the world has learned that we're just going to have to just have to live with his big mouth
Yeah.
and and um, just watch what he does. Uh, and I think again, as I have done my whole life since I was first able to vote, I think he's the right person for the right time. We just historically, Stefan, we have supported Europe and then many other areas of the world with money and manpower since World War One. We did so in World War Two. We did so in the Marshall Plan and picking up Germany and Japan and dusting them off and rebuilding them and make them into the giant democratic countries that they are now. And then in the Cold War, we fought off the Soviet Union. And when President Kennedy was elected, he policy was we will defend freedom anywhere at any time at any cost. He said so in his his election when he took the presidency. But that's changed. We've learned that we just can't do that, particularly with respect to Vietnam, for example. And we've gotten to the
I
point
vaguely
in our
remember. Weren't you a supporter of Kennedy? I remember you had a Kennedy picture or
very much,
something.
very
And
much,
and were you
very
against
much.
the Vietnam War at the time?
I was a supporter of the Vietnam War, like almost all Americans. Uh, we just didn't question government at that time,
Hmm.
and until about 1967, somewhere 66, where the flower children with flower
Hmm.
power
Hmm.
and marijuana and so forth began demonstrating. And until then, the whole country, I think, was behind the war. But they were the ones that really opened our eyes to the fact that we are pouring money down a drain, and we are we're sending our young there to die and to be maimed, and the draft is unfair. And it wasn't very long. It only took about 2 years for us to really wake up to that with all of the demonstrations. And during that time, my thinking really shifted, uh, and I still I like to study the Vietnam War books and DVDs and things like that. Um, it was a terrible time for this country. Terrible. We were
What were
really
you?
torn.
What when George Bush one went after Iraq, and then after George Bush two went after Iraq the second time? Were you? against those interventions, or what was your thought on those two?
I was very well. The Gulf War under George H.W. Bush, I did support because they had gone into Iraq, had gone into Kuwait,
yeah,
and I was supportive of that, and I think that George W. Bush did a pretty good job. One of the really unique things about that war,
episode, yeah,
it was a war, was the fact that we did it in a coalition format.
Right.
Very similar to what we did in World War II. It was the Allied forces that helped win that, although the Russians contributed substantially to that victory in Europe. But I was for that. As far as the war in Iraq under George W. Bush, I was very uneasy about that at the time, and since then I've grown to believe that it was just a mistake. We never have learned as a country how to have and implement an exit policy.
Right.
Whenever we get into any of these battles, and I think that Trump really sees that we can't be the defender of the world forever, and that we need to get back to supporting just this country. And a example of the result of that is our unbelievable debt. It's just incredible. If you look at any of the charts of the national debt, you'll see it's just tremendous. Although I must admit, if you look at the chart of so many industrial countries' debt, their debt is high too. So,
yeah, that's what happens when you have a printing press and you don't have gold to restrain you.
That's right. Yeah. Maybe that's why. Well, I believe it is a major cause of the success of Bitcoin.
Yeah, of course. Yeah, that's the thing. Are you in favor of the general idea of just cutting our losses with Ukraine and just like defending the U.S. and not worrying so much about squabbles over there?
Well, let me say this. It may take me a minute or two, but when Russia invaded Ukraine for the second time, I very much was supportive of the Ukraine cause, and contributed a lot of money to many charities. And I know a lot of people that are Ukrainian who live in New Braunfels, and we've talked about it a lot. I have come fairly recently, I think, particularly in view of Trump's opening many of our eyes about some things, that we just can't continue to pour money into these causes without understanding that they have a very negative impact on our economy. Again, the tremendous debt that this country owes. So I think Trump's idea of, well, we'll support you, but we want something in return, is very good. People need to understand, Trump is not a politician. Trump is not an entertainer. Trump is a businessman.
Right.
And he keeps talking about making a deal and so forth. We've been in the Ukrainian war for over 3 years now, and it's pretty much a stalemate.
Yeah.
Putin can run people through a meat grinder with no problem at all, just like the Russians did with success in World War II. their
Right.
their deaths and maiming, so forth, which was unbelievable,
Well,
unbelievable.
I get that attitude you talked about before about how the U.S. has been supporting Europe and all this for years. But do you think a case could be made that what really happened is that after World War II, the U.S. was dominant and used its power to force the Bretton Woods system and the dollar on the rest of the world, and we basically for 70 years been exporting our inflation and our spending onto the rest of the world by exporting that inflation onto them by making all the rest of the world use the dollar and buy T-bills and all this stuff. So in a sense, we've kind of treated the rest of the world as our vassal states who are paying tribute to us in the form of absorbing our inflation. And then we use that excess wealth that we get from having cheaper prices to pay for our military to defend them. So we've basically become a machine that outsources protection to the rest of the world that they're paying for by letting us export our dollar onto them. What do you think about that kind of argument?
Well, I think that's a very well thought out, a very well stated fact.
Mhm.
We I would define that more as a form of colonialism.
Right.
And no, I think you're right on the point there. After all, after World War II, Russia was on its knees, although it had won. Europe was shot up.
Hmm.
Britain lost all of its colonies. Japan was totally down.
Hmm.
China had not. The nationalists in China and the communists were still struggling to see who was going to be victorious there. So there really wasn't any country.
Germany was split in two.
That's right. Germany was split in two, and there really wasn't any country that could dominate politically and economically like the United States could.
Hmm.
So we did. Recently, I say recent, the last 20 years probably, China has
Hmm.
woken up to the fact that, well, communism is great, but capitalism has its benefits.
Hmm.
And they have really challenged us and in so many areas have exceeded our abilities and efforts. So the world is changing. But I think it's time to, again, Trump has advocated this, and I think he's doing it, for us to change our philosophy and say that we've got to start thinking of ourselves more than we do other countries.
Now, you sent me a text, well, which is what made me think of interviewing you about this. You sent me a note. You said, "I hope Trump gets rid of the patent office," and I was kind of surprised by that. I didn't know you had opinions about it, or I mean, I guess you would agree with me that 99% of patent attorneys, to the extent they think about it, are generally in favor of having a patent system, right?
Well, I think it's more than that. I'd say it's 99.999.
Yeah, I mean, there's
You look,
basically me, you, and about three or four other people. There's only
that's about right. Well, let me explain my thinking on that.
okay.
More, I say that with respect to patent office as a result, I think, of its failure in so many ways and by the patent office, I also mean to include the patent system.
Hmm.
I think it's failed to provide the public what the public thinks it should be providing. There's as far as intellectual property, there's only four kinds: patents, trademarks, trade secrets, and copyrights. You could put anything you want into those portals, so to speak, any kind, and it will go into one of those four. The U.S. Constitution provides for a patent system and a copyright system. It doesn't provide for a trademark system or
trade secret,
confidential information or trade
Correct.
secrets.
Correct.
So what has happened, and then to implement that, we've had the CFR Code of Federal Regulations, which has been put together by bureaucrats that have said, okay, here's the patent office, and we're going to have these. I know that there's over 1,000 patent examiners who are and they're specialized in specialized technologies. They are bureaucrats, and they what is patentable, what is an invention, oftentimes is a very subjective thing, and one of the caveats is that an invention cannot be obvious from what has gone on in the past. Obviousness is a very subjective thing. So we have these bureaucrats who or anybody who are saying, look, you can't get a patent because I think it's obvious in view of this or in view of that, and so forth. And normally that is pretty easy to overcome in patent prosecution, as we say, by getting affidavits and other evidence and arguing, look, this guy says you're wrong and this guy says you're wrong, and so forth. And we've had all of these sales of this and publications lauding the benefits of this invention to the extent that the examiner is forced to grant the patent. Well, go back for just a second. When I first started practicing patent law out of law school, the patent number in effect my first week was 3,100 and something, 3 billion. That means that there were 3 billion, quote, inventions, quote.
3 million, you said? Million?
3 million since the birth of our country.
Okay.
Since our Constitution. Now I think it's over 11 million. So my gosh, in 54 years, 55, 56 years, gee, we've had 7 million inventions. But are they really 7 million inventions? Absolutely not.
No.
Because the analogy that I like to use is that you can have a coconut cake, so to speak, and then you could cut it up into all sorts of pieces, and you have a coconut cake. Well, us patent attorneys, we can take an idea and we can separate it into we can define it, interpret it as a method or means for doing something or a composition. We can take one invention and file 6 or 8 different, and we can split it up just like a cake. And lo and behold, you have 6 patents for one basic idea.
Well, and not only that, wouldn't you agree that the basic idea is not necessarily original because the patent office might be wrong? And number 2, it's a judgment call about whether it's sufficiently non-obvious over the prior art to be considered a new contribution. Like all these are judgment calls, and there's a lot of incompetence on the part of the patent office just because of its nature.
No question about it. No question about it. That's very true. What I'm leading up to is this: the patent system has really evolved into a system that benefits corporations
Mm-hmm.
and big business versus the individual.
Mm-hmm.
Although fees and so forth are a lot less for individuals and small entities than they are for corporations, an individual is at a tremendous disadvantage in the patent system.
Yeah.
The just an example of that. Let me digress for a moment. Just an example of that is these advertisements on radio and television by these invention development companies.
Mm-hmm.
You got an idea? Come to us,
Mm-hmm.
and we'll prepare your patent application.
Mm-hmm.
We'll market it and so forth.
Mm-hmm.
And the inventor or an idea sitting by an inventor sitting by his fireplace picks up the phone and calls or sends them his disclosure. And you and I and any other patent attorney worth their salt can prepare a patent application on anything, and so these companies will do so. They'll say, yeah, we think you can get a patent for this. It only costs you this many $1,000 or whatever. Pay up, and this is after you've paid them a fee to search and see whether or not it's patentable. And so what you get out of this is a patent. For example, you had two boards, board 1 and board 2, and your invention was securing them together.
Mm-hmm.
And this invention development company writes a patent application, and the invention is defined as two boards secured together with screws. Well, that's nice, and they've gotten you your patent, but it isn't worth 5 cents. Why is that? Because somebody that secures the boards with a nail or glue or a spring or whatever would not violate the patent. So what I'm saying is you pay your money by these individuals and you get a very narrow, very unprotectable patent.
Yeah. Well, Bill, the impression I've gotten over the years is these invention submission companies, not only do they do that, but what they do most of the time is they will just say, "Oh yeah, we can get you a patent on that," but what they mean is a design patent, not a utility patent. And
Absolutely.
most normal people don't know the
Absolutely.
difference, and they think that if they get a design patent, that's a patent. But they don't understand that's just like it's more like a copyright. It's just on the ornamental way something looks, which is almost useless.
Absolutely.
So
Absolutely.
that was the impression I got. Most of these companies are basically ripping people off by giving them a bait and switch and saying, "We'll get you a patent," but then they get them a design patent, not a utility patent.
Absolutely. That's another example of they'll get you a patent that is extremely narrow.
Yeah.
With respect to the patent, to the protection. But there's something else, Stephan, that I really bothers me about the patent system, and that is that this is important for corporations and as well as individuals. From my vantage point, since I spent so much time of my career in the litigation area, both representing plaintiffs and defendants, and I've represented some of the largest in the world and defended against some of the largest in the world, as well as some of the smallest. But the point is this: I think that a patent is nothing more than a free ticket to get into federal court to enforce your patent. For example, you have a patent and then this company gets wind of this idea that you have because it's being marketed or whatever, and they start infringing the patent or violating it. And you what do? You knock on their door and you send them a notice and say, I have this patent that covers this. And the infringer says, sue me
Yeah.
because I'm not going to stop.
Yeah.
The cost of doing that and the time that it takes is enormous. And so what I'm saying is, for the individual as well as corporations, you don't have anything until it's proven in court. And those litigations, I've had patent litigation in one form or another, including appeals and reversals by the appellate court, sending it back down to the district court, trial court, that lasted as long as 8 or 9 years. And
yeah, it's a lot of money for the lawyers. I can't tell you how many times I've heard the argument that, well, we need a patent system to protect the little guy, and it's like, even when you pointed out that the fees you have to pay to the patent office are lower for individuals, that's nothing compared to the cost of litigation, which an individual can't afford to engage in or to defend himself from. So basically, it just leads to these cartels and monopolies of these big companies.
Absolutely. So what I'm saying is that an individual or even small corporation or even large corporations, the cost of procuring a patent should also include the cost when you're doing a budget, the cost of enforcing it. So I have a kind of a unique idea of what our patent system should look like.
Okay.
And that is the following. I think we should dismiss the patent office. This is never going to happen, Stephen. Never going to happen, but for a lot of reasons. But I think we should phase out the patent office, and then we should have a committee run by the administration or whatever that selects 10 or 20 great inventions every year. And give them an award. And perhaps a monetary compensation or something. It should be something that's recognized. Now, I know that's a silly approach, but and as far as the patent system is that we have now, it stimulates the economy very much. It keeps a lot of attorneys very, very busy. And it keeps a lot of patent draftsmen, those that have to do the drawings, and it keeps people like me really fat. I can buy my wife a new Lexus or whatever whenever she wants it. So you and I have prospered and have smoked many a cigar being an advocate, or I would say participant, in the patent system.
I think Elon Musk might call that fraud, waste, and abuse, or at least waste.
There you go.
Yeah, the way I look at my job, I get criticized by people that they're pro-patent, and they don't like the fact that I'm a patent lawyer who is opposed to it. And I point out that it's sort of like if you're an oncologist. You're a doctor who wants to fight cancer. You get paid to fight cancer because people have it, but you would prefer a world where there's no cancer. So there's no hypocrisy there. And when as long as we live in a world where there's a patent system, companies need advice, they need help. So we're necessary given that there is a patent system. It doesn't mean there should be one. And as far as your idea about a patent award, it's not a silly idea. Lots of people have come up with that idea. I think Alex Tabarrok, some economists, and that would be a better system if we just said, look, let's have the government have some tax dollars and have a commission and give out $20 billion a year to the top 500 inventions of the year to stimulate that and to reward these guys. It would be a lot cheaper than the harm the patent system does. Now, the problem is if you took that logic, like if you said we need to have an incentive from the government to cover every type of invention that the patent system covers, then that kind of award system would cost probably $20 trillion a year. I mean, it's impossible. So it would have to be just selective. And I
Of
have
course.
proposed, as far as patent reform, I proposed, I mean, I think we should abolish it, but some improvements you could make is number one, you could say there should be no injunctions, which are harder to get now anyway, after was it eBay or whatever case it was that made injunctions harder to get. But you could also go to a petty patent system like some countries have, where there's no presumption of validity and there's no examination. You just file it and it's on file, and then it wouldn't be able to be used as a weapon as easily against the defendant. You'd have to prove in court that it was valid. So there's lots of things you could do to tinker around the margins, I think.
Well, that's true. The thinking of our forefathers in putting protection into the Constitution through patents was that it was a quid pro quo. That is, if you disclose to us your great idea,
Yeah.
Benjamin Franklin and electricity, for example, and things like that, if you'll disclose those, we'll give you the exclusive right
Yeah.
to practice that invention, to sell it, to market it for
Yeah.
what was originally 17 years. Now it's
It was
20.
it was actually,
out.
I think it was 14 originally, 14, and then it went to
That's correct.
17.
That's correct.
Copyright was 14 originally, and then it went to 28, and then it went to
That's
life plus 70. It's crazy.
correct.
Let me offer a slightly different take on that and see what you think. So what you're referring to is what we call the patent bargain, which is in the patent law. It's not in the Constitution. The patent law says
Oh, yeah, that's correct.
says we will give you a patent, which is like a monopoly, a protection from competition, in exchange for your full disclosure, which is the patent application or the disclosure. So the bargain is you tell us how to make this, which people can use later on after the patent expires, and in exchange, we're going to give you exclusive protection for 17 years.
Right.
The
And
patent clause in the Constitution only says that Congress has this kind of general power to do this.
Absolutely, absolutely. And the theory for having this is, well, you disclose this to others, and that will help to stimulate ideas on second and third and fourth generation improvements into the science that it is directed. It will stimulate additional ideas and therefore move technology and the quality of life, etc.
And the theory behind that is that the free market doesn't work that well. There's sometimes market failure, and you have an underproduction of innovative goods if you let people just fight it out on the free market. So the government has to kind of step in and fix this with this little patch. But to my mind, that's more of a recent after the fact rationalization or justification. That wasn't really the purpose of the patent system in the beginning, which people have forgotten. If you recall, what happened was back in Europe in the 15, 1600s, you had this rampant practice of monarchs granting patents. They called them patents, which were just sometimes it was a land grant, sometimes it was the exclusive right to sell a good in a given area, and they were just protectionist, mercantilist grants of monopoly privilege. And when it got out of hand, the Parliament in England in 1623 passed the statute of monopolies to rein that in a little bit, but they grant patents for inventions. So that the origin of patents was not to stimulate invention; it was to let the king get favors from people by giving them these privileges.
Absolutely.
And then later on,
as the Industrial Revolution caught on, that concept of having it a grant of what I would call special favors, transformed into industry.
Right. And so then you had these special interests who got dependent on it, and they started fighting back when there was free market economists in the 1800s who were saying we should get rid of the patent system because it's a distortion of the free market. So they started saying, well, it's not a privilege, it's a form of property, it's intellectual property. So they started calling it that But it wasn't until the 1950s when Congress commissioned this economist named Fritz Machlup to do a study to find out empirically whether the patent system really does stimulate invention or not. And he did this big study in the 50s and concluded that there's no evidence to show that the patent system does anything good at all. So there's really no evidence for the theory, which is that it's necessary to stimulate more innovation or that it does stimulate more innovation. It's just an unproven assertion, and we have this whole system now based upon this theory, which is no one's been able to prove.
Well, that's true, and that's an excellent summary of the history of it. One other point, looking forward or looking to today's, it's even worse because if you have a patent or publication of the patent application before it issues, or whatever the point is, for example, the Chinese get wind of this and so forth, and they duplicate it or even improve it and sell it to the rest of the world except in the U.S., there's absolutely nothing you can do about it unless and until you have a patent in the particular foreign country that, for example, the Chinese are selling to. And those are very costly. And guess what? Once you get outside of the Anglo-American judicial system, you don't have any judicial system, or that is a cause of action to correct an injustice.
I think. Are you saying that patent rights and intellectual property rights in countries like China are not as enforceable as they are in Western countries? Is that what you're saying?
That's what I'm saying.
Yeah.
And I'm also saying, I know from experience. Let me give you an example of that. Years and years ago, a client of mine had a particular product, an oil drilling product that they were selling to the National Oil Company in Nigeria. And one of their competitors was selling the same thing. Well, we did have a patent in Nigeria. And so, I'm sorry, this was in Gabon, Gabon, I believe. The former French colonial territory. Well, the way we got that enforced, I went to France and met with my French associates there, attorneys, and they had an attorney in Gabon, and he flew to Paris. We all had a confab about this. I remember trying to explain the patent and so forth and so on. And this attorney from Gabon or whatever African country it was came, and he was dressed in his home attire, very colorful and so forth, with a turban and so forth. And he didn't seem to be paying any attention to me. And he spoke French, and I got an interpretation of this through my French associate, and he would say, "Yes, don't worry about it. We'll take care of it." And I kept saying, "Well, how long is it going to take, and what's the cost, and all this stuff?" Because I had to report to my client about this, and I could never get any real clear answers from this guy except not to worry. Well, I went home to flew back to Houston and told the client, what had happened and so forth, and I said not to worry. And of course, the client was a little unhappy about this, or a little confused. Well, 2 weeks later, we got a note from my French associate that this lawyer in Gabon had telegraphed them and said that the infringing devices of the competitor had been impounded at the importation docks. They would not let them through. And in effect, the patent had been enforced. I finally found out who or how they did it. The lawyer in this African country was the brother of the president of that company. So that's how and I had that experience in several other countries. I had that in Iran before the fall of the Shah. A lawyer there that we retained was, I believe, the brother-in-law of the Shah. No problem. That's how you get it done. It cost us a little bit of money, but that's how you got it done. Concept of having a jury and a judge in a court.
Yeah.
Get it. Only
Well,
in,
I'll defer to your experience on this. My understanding is that in China, for example, and in Europe and in other parts of the world, they do have patent systems and they do work. It's just that they don't work. They're not quite as maybe efficient or draconian as the U.S. But the way I look at it is there's infringement in any country. The U.S. system doesn't stop all infringement, and the Chinese system doesn't stop it all. The point is, they both have patent laws, and they both have an effect on competition and innovation. So the degree is there's a difference in degree, but I don't know if it's a difference in kind anymore.
well, my my experience. You may be right. You very well may be right. You're probably right, knowing you. But my experience was, and I told my clients this all the way through my career. I had clients that filed patents all over the place, in many, many countries. But I would caution them before they spent the money. This is how it's going to work. Once you get the patent and so forth, you may want to use it for licensing as a vehicle for licensing and things like that. But as far as enforcing, let me tell you, it's not like it is in the United States.
Right.
In the United States, it takes a while to get the patent litigated and so forth. But if you're successful, in it, you're the plaintiff. The damages that you can get are awesome. But
you mentioned this. Let me mention something for the listeners. So the patent system is a national-based system. Every country has its own patent law. Most have the patent law because they're members of various treaties, like the Patent Cooperation Treaty and the Patent Paris Convention. But the patent law is domestic, which means that. So, and this is another reason why intellectual property is different than normal property. Like if I have a property right in my home in Houston, I only need that to be recognized by one legal system, the Texas one, because it's still good against the rest of the world. But if I have a patent right in an invention, it's only enforceable in U.S. under U.S. patent law. If you want it to be enforceable in other countries, you have to file another patent in the other countries. And this is another reason why this is not for the little guys, for the big guy, because you're talking about $10,000, $20,000 for U.S. and now you've got to multiply that times, I don't know, 50 other countries or 20 other countries or 200 other countries. It's just impossible. So only the big companies can afford to have a Chinese patent and a European patent and an Australian patent and a Canadian patent and a Japanese patent, in addition to the U.S. Right? So that's another reason this is not for the little guys, for the big guys only.
I agree with that. That's a wonderful example of supporting my contention that patent system has evolved into a system of use by large corporations. You and I both know many companies have a staff of 10, 20, even 100 patent attorneys that don't do anything but crank out paper on just ideas that people have that never have and never will be turned into a product. You said something that I want to point out that I kind of disagree with. Well, I definitely do. One time I did have in Beaumont a lawsuit that involved trade dress and breach of contract and trade secret information, as well as copyright information, and it was against a consortium of infomercial companies, but that's irrelevant. But the point is that my client did not have a U.S. patent. They only had a foreign patent, and so we brought a patent infringement action against him, and the judge allowed it. And I don't know whether it would have withstood a challenge on appeal. We never got that far. But even in my resume for a while, I touted the fact that I'd represented this company that was the only one that we knew of in which a foreign patent was.
I've never heard of that. To my mind, that's just an example of number one, this law is not an objective law. They're just made up laws. And number two, it's a symbol of the corruption and the inefficiency of the state court system. I mean, they don't know what they're doing half the time. They don't care about justice. They just follow the rules written on paper, and sometimes you get crazy results because the law makes no sense anyway. But I'm not too surprised by that.
Well, that's true. That's true, and that's. Go ahead.
Before we get to I want to ask you a couple more questions about patent, but I want to ask you a couple things about the IP system in general. You were talking earlier about how the Constitution authorizes, and by the way, most patent lawyers don't even recognize this. So you understand it, that the patents, the copyright and patent system are authorized in the Constitution, but trademark and trade secret are not. And what the government, what the Congress did with the Uniform Trade Secrets Act and with the Lanham Act, which is the Trademark Act, is they got those in by using the Interstate Commerce Clause, which I think has been wildly overconstrued by the courts to allow Congress to legislate on whatever they want. The Interstate Commerce Clause was never meant to be a general grant of legislative power, but that's how the Congress uses it when they use that Wickard v. Filburn idea that Congress can regulate anything that affects interstate commerce. And so that's how they got the Lanham Act for trademarks and the the Uniform Trade Secret Act enacted, or whatever it's called. There's a federal trade secret law. And so I think those are totally unconstitutional because there is no authority for Congress to legislate in those two fields under the Constitution's copyright and patent clause.
Oh, I agree with that. They did use the Commerce Clause as the vehicle for extending protection into those two other intellectual property rights concepts.
Yeah.
One thing we haven't talked about, Stefan. It's also I think very important in this is the concept of certain areas in the country turning into manufacturing facilities for patent litigation.
Oh yeah.
It's just, and I think it's an interesting story. There is, and it goes something like this. There is a district in a state that the mayor and the city council and the attorneys bar and so forth said, "Gee, you know, we're the economy here is pretty bad. What can we do to stimulate our economy?"
Hey, Bill. Okay, we're recording again. I had a bathroom break. Go ahead. You were telling me, so you have some town who wants to get some stimulation of the local economy. Go ahead.
Right, and so then they met with the Chamber of Commerce, and the Chamber of Commerce said, "Yeah, our hotels and motels here and restaurants and taxi services and so forth could really need a boost. So they said, hey, let's have a specialty here in a special type of law, and we'll have what we call a rocket docket, and we'll have special rules and regulations, local rules, and so forth for speeding up this litigation, and we'll all make a bundle of money, and all sorts of corporations would come here. Well, lo and behold, they did. And everybody and their uncle who had a patent would file in this obscure district, federal district. Patent lawsuits are filed only in federal court, and they would have a rule. For example, you can't have if we have a hearing on an item, you must appear here. The lead attorney must appear here in person, no phone calls. And oh, by the way, you must hire local counsel here to make sure that our local attorneys are fully employed. And you must stay at one of our hotels and so forth. And this particular district, just for years and years and years, really made a bundle off of patent litigation for everybody, and it was very prosperous. So this is one of the few examples. Well, there's a lot of others.
And you're talking about Marshall, Texas, the Eastern District of Texas, correct?
I wasn't going to say it. You did.
Oh yeah, I'll say it.
But anyway, this is just another example of the stimulation of the economy that I think is improper, and the Supreme Court put the quotas on this several years ago, but they still do a nice business there, but not nearly what they used to, because the Supreme Court stepped in and said, "Hey, this."
They put a limit. They try to put some limits on forum shopping. We call it forum shopping.
That's correct. That's correct.
Well, I wanted to ask you a couple more things about patent system, but one more thing I wanted to ask you about an argument I have and see what you think about it.
Yeah.
So the copyright and the patent law are enacted. Well, they were first enacted in 1790, right after the Constitution was ratified in 1789, pursuant to the copyright and patent clause in the Constitution. But then in the next Congress in 1791, the Bill of Rights was ratified and added to the Constitution. And the Bill of Rights has the First Amendment, which is the free speech and freedom of press clause, which says Congress shall make no law restricting freedom of the press, basically. Now, could you argue that that clause or the First Amendment effectively made the copyright law unconstitutional, because copyright does restrict freedom of the press, because you can have a federal court ordering someone not to publish a book? So would you agree that there's a conflict between the copyright law and the First Amendment, freedom of the press?
I would have to give that. That's some very creative thinking. I would have to give that to the thought. I would be troubled by that position for the following reason. Copyright law only applies to actual copying. If you came up with the same idea and even use the same words and photographs in a book or brochure or whatever, you had never seen the copyrighted work, never had access to it in any way, you would be free to market it and publish it and what have you.
Yeah, you're getting at the idea expression dichotomy. You're saying that it's only the expression that's covered, not the underlying ideas.
That is correct. That is correct. So I'd have, and that's an interesting concept, Stefan. I'd have to give that.
Mhm.
I'd have to give that some thought, but that's certainly, I would say, a justifiable
Mhm.
argument.
From what I've seen, the courts have recognized that there is what they call a tension between copyright law and the First Amendment. So what they say is their intention, which to my mind means that they're incompatible. But what the courts do is they say, well, we have to balance it. So they think we don't have to totally outlaw copyright, but we have to like respect the First Amendment to some degree. So they try to balance it. But to my mind, the First Amendment came later. So it should dominate if there's a conflict. It shouldn't be a balance. It should be like a later amendment to the Constitution that overrides an earlier one, like the like prohibition. You know, prohibition was overturned by a later amendment.
Oh,
Um,
absolutely, absolutely. Well, I'd like your. I'd want to think about that concept, but the one I really like and totally agree with is that copyright uh, law, although it's expressed in the Constitution, really um, is not what our founding fathers intended for it to
Correct.
be.
Yeah. I think 14 years. There's a guy that advocates for going back to what he calls the founder's copyright, just 14 years, not life of the author plus 70.
Oh,
It
absolutely.
shouldn't extend to like software. It should just be for basically books and paintings, maybe.
Oh,
Not
absolutely.
even music. Um, I wonder.
Absolutely.
I'm sure you've been aware of the Supreme Court in recent years chipping away at the Chevron doctrine,
Absolutely.
which
Yes.
gives this sort of presumption of uh, legitimacy to the regulations issued by federal agencies that are under the
In
executive.
any
Yeah,
in any agency of the federal government, not just patents.
right. So there's all these agencies that Congress created by legislation, but they're under the executive branch, but they have rulemaking power, which is kind of quasi-legislative, and they sometimes have quasi judicial power too. They can hear like I think the international trade.
Absolutely.
And so
Absolutely.
I think it's potentially a violation of separation of powers, but also Chevron is now been reversed. So I wonder if that might end up meaning um, people could challenge in federal court some of the patent office regulations that they promulgated as a way to interpret the Patent Act. I just wonder if Chevron it could lead to some more defenses by patent defendants based upon Chevron. I don't know. I'm just wondering in federal court if that could be something that might be
Well,
emerging.
I mentioned that at the beginning of our discussion through the Code of Federal Regulations (CFR), which is just
Yeah,
created by bureaucrats on
right.
how to implement uh, congressional laws and um, so forth. So yes, I certainly agree with that, and I think this turn to the right by the Supreme Court is going to mean that a lot of these rules and regulations that have been set up by the patent office are going to be pulled back.
Yeah,
Uh,
I wonder too.
I
Well,
think that's very. I
so
think
let's
that's
get
very.
let's get back to the patent thing. So you said in the beginning you hope that they get rid of the patent system, and then you had some ideas about maybe to improve it by going to an award system. Um,
Yeah,
but are you and you kind of have this view, I think, that the original purpose of the patent system was to stimulate innovation, but it's turned into something different. Do you so if you had I mean, are you really serious? Would you really favor yourself literally abolishing the entire patent system, or would you prefer to modify it? If you, I mean, or do you really think the whole thing is a joke and corrupt and doesn't do what its promises to do, which is to stimulate innovation, or do you think it's just broken or just needs to be fixed? Like, what's your real opinion on that?
it's not just the patent office; it's the patent system. I've seen so many things, so many cases, both representing plaintiffs and defendants, in which whether I won or lost on behalf of the client, it could have gone the other way.
Mm-hmm.
In a lot of ways, a lot of intervening items came in, and that is the demeanor and recognition and so forth of expert witnesses and things like this. It's gotten very distorted. Let me put it that way. Am I against the patent system? It's in the form that it's in now, yes.
Well, let me ask you this: if tomorrow Donald Trump got Congress to pass a law just abolishing the patent system, would you be very upset about that?
Being retired, no.
Just getting yeah, okay, right. Yeah, I know it helped you and me in our careers, but and let me ask you this: if the patent system disappeared tomorrow, do you think this would mean that innovation would stop?
No, absolutely not. I think it's in the mind, in the civilized man and woman mind to move forward and advance society. And we've done this since the caveman and the development of fire and the wheel and so forth. Absolutely not. I think the people that I have known and worked with in my career had brilliant minds. They were creative people.
Mm-hmm.
They really didn't give a damn about the patents.
Right.
Another point on this, in direct answer to your question, is that patents are applications a lot of times are approved to be pursued in corporations to be warm fuzzies for engineers and designers and so forth. Oh, this man has 3 patents, et cetera, et cetera, et cetera.
Right.
And there's not any care about protectionism and going into the market and so forth. But mankind in our entire society, the development of the Industrial Revolution, the evolution of that, is in the genes, so to speak, of humanity.
Yeah.
I don't think it would affect it a bit.
And if you ask your typical fellow patent lawyer, what would they say to the proposal to get rid of the patent office?
They'd say, look, I've got a car payment, I got a house payment, I got to put my kid through college. And not only that, this is the only area of the law that I know anything about. I couldn't get my wife off of a parking ticket if I had to.
But if they had to defend the patent system other than from self-interest, do you think they would just repeat what they heard in law school, that, oh, you need it for innovation, something like that?
Yes, I do.
Yeah.
I think they would. It would be called self-personal advocacy, and they, we always, when we were practicing in this area, we supported it because we were just surrounded. We breathed it. The air was different, and
it was our plasma.
That's all that. We never took time to step back and see what kind of animal is this that we're living with.
Well, and let me ask you this: or do you feel free to say this right now because you're retired, or would you have said this 15 years ago if someone had just asked you, would you be upset if the patent system is abolished? Would you have been leery about saying that while you had active clients, or would you not care even then?
I did say it, and I said it in many aspects. Clients, I remember talking to one particular client I had about patents. He said, you know something? He said, if we hadn't had the first one, we wouldn't need the second one. And I've always laughed at that, and I think it's very true. But I have discussed with clients my concern about just getting a patent, because I felt that the only good patent was a litigated patent, and it costs so much to litigate it. And I would, a lot of times, for example, with a client, they would say, well, when is this lawsuit going to be over? Why are we having all these hearings? And why do I have to produce all these documents and all of these people for depositions and so forth? And, I would explain to them, look, it's just the system, and the system is lousy, and it's ineffective, and it's hard to turn around, just like any other law or procedure that you have. It just takes time, and that's what Democrats and independents need to understand about Mr. Trump. Even though he's moving at lightning speed, it's going to take a while for these concepts that he has to take hold, because they are so contra to the way that we have been thinking for 50 and 100 years.
Yeah, I also think that the criticism of like Musk taking the chainsaw approach, the criticism is off base, because honestly, at this point, that's the only way to do it. Because if you try incrementally, you're going to get blocked. You're never going to make change, and you're going to have the system we've had for 70 years. So the only way to make change is to take a chainsaw approach. And then if you find out you made a mistake and you took something out that you need, you can always add it back, right? There's no reason you can't just add part of the federal government back.
Oh, yeah.
All right. Well, look, Bill, I've taken a lot of your time. I appreciate your time. I'm going to post this later, and I'll send it to you. And when you're back in town in Houston, let's get together and break bread.
Well, I don't want to do bread. Let's have another margarita drinking contest. All right, buddy. Good talking to you.
You too. Take care. We'll catch up later.
All right. Bye-bye.
Bye-bye.